Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now,
beautiful day in Crestview, beautiful courtroom. Everyone's happy to be here, I'm sure. Except some people, maybe. You want to just go right down the docket?
Sure, Judge.
Mr. Nopes, how about you then? You look like you're ready to go.
I've got Darren Jacob over 8. Sign this from the record.
Judge, I think he was an add-on, so he's not going to be on the docket.
Okay, I don't have him on my list. What are we here for then?
Judge, it's going to be a plea. Well, I say if I can hold on to my pen, it'll be a plea.
Okay.
If I may approach, Your Honor.
Morning.
Judge, Mr. Taylor's got a violation of probation in 22 CF 632 that he's admitting at this time. And then he's got a new law violation, 23 CF 628, that he's going to enter no contest plea. Understanding with the state is he's adjudicated guilty, 11 months, 29 days in the county jail, credit for time served. Everything's concurrent, and the balance of the conditions are on the plea form, Your Honor.
Mr. Tolar, is that correct, sir?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give before this court's the truth, so help you God.
Yes, sir.
You want to enter admission to violating your probation and also enter a no contest plea to these new charges?
Yes, sir.
That's 22 CF 632 and 23 CF 628. And you are entering a plea to, is it straight up to these charges, Mr. Nopes?
Judge, we're entering a plea with the, yes, sir, we're entering a plea to the new law violation as well as the VOP.
All
and
right.
the terms and conditions as agreed upon with the state are on the form.
All right, so it's in 23 CF 628, it's grand theft, possession of, and that's a third-degree felony, possession of retail stolen credit debit card, a third-degree felony, and illegal use of a credit card 2 times, and that's a third-degree felony, and then the VOP. Mr. Tolar, did you read and sign this? All right, this is 23 CF 806, 23 CF 744, and you are Julius Wilkes.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give forward is course of truth, so help you God?
Yes, sir.
All right, you want to enter a no contest plea to, in 23 CF 806, possession of a controlled substance, a third-degree felony, and also resisting without violence, a misdemeanor, first degree, and in 23 CF 744, a driving license suspended, a third-degree felony. You want to enter a no contest plea to those charges, correct? Did you read and sign this plea and sentencing agreement form?
Sir.
You
Yes,
aware of
I
the
did.
rights you're waiving by entering this plea? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
You happy with the work Ms. Rivers has done for you on your case?
Yes, sir. She did an excellent job.
Very good. Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty, all counts of both cases. 515 court costs on 23 CF 806, $100 cost of prosecution, $150 PD fee, and 23 CF 744. In that case, 23 CF 806, you're sentenced to credit for time served. You're probably looking for that, weren't you? Yeah.
Yes, sir. Yes, sir. I was.
And then in 23 CF 744, credit for time served, and also 415 court costs, $100 cost of prosecution, $100 PD fee. So I presume you're getting out today, okay?
Yes.
Don't get in. See what a hassle getting into trouble causes you. You got to dress in orange every day.
Yeah, I didn't know I was jaywalking.
You got to get your gear in jail. So just stay out of trouble, okay?
Yes, sir. Thank you, Mr. Gontarek. Thank you.
You too.
And this is who?
This is Miss Pittman. This is Christina Pittman. Her office.
All right. Can you tell me where she is on the paperwork? 14, okay. Christina Marie Pittman, okay.
All right. Your Honor, she just needs a moment to sign the plea agreement.
Okay.
Let me see where. There you Is that what you want to do? Your Honor, we reached an agreement in this matter, if I may approach.
All right. Ms. Pittman, would you please raise your right hand to be sworn? You swear the testimony you give for is court's truth, so help you God?
Yes, sir.
Okay. You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights you're waiving?
I went over some of the rights with her, Your Honor. She just was presented it at this time.
You understand your rights you're waiving by entering this violation of probation, this admission to violating probation?
Yes, sir.
You understand it? Mainly that you have a right to a trial before me, and you're waiving that right. You understand that?
Yes, sir.
Okay. Does anyone force you or threaten you to enter this violation of probation? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers done for you on your case? Court finds the admission is freely and voluntarily entered. Court accepts it, revokes and terminates probation. $89.45 cost of transportation. I guess that's Okaloosa County Sheriff's Office. Is that right?
Yes, sir.
45 days county jail from May 16, 2023. $100 cost of prosecution, $150 PD fee. And you're adjudicated. Anything further? Thank you.
Revoke and terminate? Did you say that, Your Honor?
Yes.
Okay, thank you.
Revoke and terminate.
Those outstanding monies go to collections, Your Honor.
Yes. Next. Miss Rivers, more cases? Miss Flowers, okay. Morning.
Yeah, that's right.
Is it Agent? Good morning, Your Honor. Jennifer Flowers with RCC. For the record, on behalf of Brianna Bagent, we're here on a motion to reduce bond today and just a motion to clarify bond as well. She was originally arrested and charged with, I believe, 4 counts.
Before you go, can you tell me where she is on the docket? 10? What's her name again?
Bagent is the last name, Baigent, Brianna.
I don't seem, I have someone else's name on number 10. I don't have her name on my docket.
Let's see.
Okay, well, anyway.
Well, I filed a motion. I don't know if the courts had a chance to review it, so I'll just go through the facts.
All right.
She was arrested in April and charged with accessory after a fact of a first-degree felony, accessory after the fact of a second-degree felony, and then 2 counts of accessory on a third. The bonds were set on each of those counts. Since then, the state has only filed on count 1, the accessory after the fact of a first-degree felony, has not filed on the other counts. So we're asking to set ROR bonds on the counts that haven't been filed on by the state, as well as we're asking to reduce the bond, which is in the amount of $15,000 cash or professional on the charge that has been filed on. Just arguing that Ms. Bagent is indigent, she cannot afford to post such a high bond, that she's not alleged to have committed any violence in this offense, and she originally was charged with a misdemeanor, basically for not cooperating with law enforcement. She since has cooperated, but now has been charged, with a first-degree felony. So she understands the seriousness of it, but we just wanted to get the bonds straight today, get the RORs on the ones that haven't been filed on, and see if Your Honor would consider a signature bond so that she could not wait in jail as we figure this case out.
Your Honor, the state would not object to the ROR bonds on the charges that the state hasn't filed on. However, and also, the state would be agreeable to applying a GPS monitor should the court grant defendant's motion for an ROR or signature bond to the count that was charged by the state.
Okay, 15,000 signature bond with a GPS monitor, $1 a day ROR and the rest.
And I would ask the court to add conditions such as no contact with the defendant Durham, no contact with the victims in the case.
Same, I'll add those conditions also. Okay?
Will she be on she will be on pretrial release because she'll have the GPS monitor. Okay.
Yes, Your Honor.
All right,
Thank you, Your Honor.
thank you.
Okay. Where she is on the docket.
Number 10, 11.
She's prepared to enter a plea. We have a plea agreement where, she's admitting her violation of probation.
Ms. Taylor, would you please raise your right hand and be sworn? You swear the testimony you give for is course the truth, so help you God?
Yes, sir.
Okay.
Yeah, please sign it. Approach with the plea.
Ms. Taylor, you want to enter an admission to violation of probation in 21 CF 1089. Is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which you waive your rights? You
Yes, sir.
understand, and you understand that? Anyone force you, threaten you to enter this admission?
Yes, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Court finds the admissions freely and voluntarily entered. Court accepts it, adjudicates you guilty, revoke and terminate probation. Sentenced to 6 months Okaloosa County Jail, credit for time served, $100 VOP cost of prosecution, $150 cost of defense, to be paid with 180 days of release from jail, then to collections, and adjudicated.
Yeah.
Thank you.
Mr. Goodman?
Ernest Tom Goodman?
Yes, sir.
Okay.
Yes, Your Honor, for the record, Jennifer Flowers with RCC on behalf of Mr. Goodman. We're here today to address a bond on his VOP cases, VOP case 21 CF 971. When he was arrested in October of 2022, and his new law violation that we're currently still fighting and going through depositions, and there's actually a pending motion to suppress in that case as well. But at that time, back in October 2022, he was given no bond on his VOP. He's not had a bond hearing since then to address bond on his VOP. He's been incarcerated in Okaloosa County Jail since October 7th, 2022. The court may grant a bond on a VOP pursuant to, and I put the statute on there. The main thing is that this defendant has ample work opportunities outside of the Okaloosa County Jail. He has the ability he had a job working high up in a company as a projects manager, making lots of money. His intention, he would really like to get out so that he can make some money and hire a private attorney. That's what he wants to do, but, so he's asking the court to consider some sort of bond on his violation of probation. He's got 2 children. One is only a year old. The other one is 6 years old. Since he's been in jail, they've had to move back in with his fiance's mother. His plan is to live with his mother in Crestview locally. He's been here locally his whole life, and intends to come to court. And his intention, what he wants to do is to get out, make money, and hire a private attorney. He wants to provide for his family, and he's just asking for the court to entertain any sort of bond.
Yes, ma'am.
Your Honor, the state objects to defendant's request for bond. First of all, he's charged with trafficking in amphetamine, carrying concealed firearm, and the trafficking in methamphetamine carries a 3-year minimum mandatory. He scores a minimum guidelines presumptive months, 61 months. He has as prior record 2 failure to appear for misdemeanor, 1 failure to appear for a felony, 1 grand theft of a motor vehicle, felony battery, sale, manufacture, deliver of cocaine, willful fleeing and eluding to, possession of cocaine, felony DWLSR. He was on probation on 2 cases, 21 CF 971 for driving while license suspended, and he was on probation in 20 CF 2967, where he was charged with trafficking in oxycodone. The state believes at this time that the bond for the VOP cases should be revoked, stay revoked.
Court finds there's too much of a prior record and minimum mandatory is looking at, so I'm going to leave the bonds the way they are. Thank you.
Thank you.
He's not considering This is, Your Honor, this is Mr. Whitted, Jennifer Flowers, for the record, on his behalf. Your Honor, this is kind of an interesting case, and I need to talk to the prosecutor about it. So to make a long story short, we need to continue this matter so that I can clarify what's going on with.
You want to continue to June 8th?
Judge, could we have the next date? I'm going to be out of town that
Is
week.
June
Trying to sit in jail that long.
29th?
I'm sorry?
What day you want?
Do we have one at the, towards the end of June? The
June 29th?
Yes, sir.
All right. June 29th. Thank you.
Basically.
Next.
Judge, I can call Crystal Hall.
Crystal
Unless
Hall?
Ms. Flowers has another client. Okay. She does, okay.
Next case.
I have an out of custody. Is that all my names? Oh, no. Ms. Walker? Is Ms. Walker here? I do have Travis Anderson out of custody.
Travis Anderson. Okay.
Yes, we were hoping to have a resolution today, but we're going to have to, because of some circumstances, put this, we're requesting to put it on the pretrial docket. Back on.
June, let's see, 26th? Okay. June 26th.
Thank you. Okay. 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 So she won't come over at all today? That's okay. We can, could we address Lisa Walker? She's not here, but I would like, could we put her on the next miscellaneous date? For what? To, her other.
How about June 8th? You ready?
So, yes, if we could just put Lisa Walker's case on the next miscellaneous date, since she's not here, she wasn't transported.
And that'd be, well, the next one is, that I have is June 8th. Is that what you
That's
want?
fine.
You want to do that one?
Okay. Yeah,
June
June 8th
8th.
is good.
Okay.
Okay. All right, and I think that's all. I was double checking to see if that was all I had on today's docket.
Okay.
Yeah. Yes, Your Honor. Thank you. May I be excused?
Yeah.
Good morning, Your Honor.
Mr. Stewart?
May it please the court, Brad Stewart present. I'm covering for Dixie Powell, Judge.
All right.
He has two matters on the docket. Mr. Christopher Kearns. Kearns is present, Judge, and as he approaches, this is going to be a plea into PTI, Judge.
All right.
I do have a signed written plea agreement. Your Honor, may I approach?
Okay. Mr. Kearns, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Okay, thank you.
And for the record, Judge, this is 22 CF 2488, Judge, and Mr. Kearns is prepared to tender a plea of no contest to counts 1 and 2. Sentencing will be deferred in lieu of completion of the pretrial intervention program. He'll be able to mail in reporting and requesting that the monthly supervision fees be waived. He'll be required to complete the anger management course during the program.
All right, Mr. Kearns, you want to enter a no contest plea in 22 CF 2488 to felony battery and threat against law enforcement officer. Is that a felony also, Mr. Stewart, the second one?
No, Judge, I believe that's a misdemeanor.
Misdemeanor?
Yes.
Yeah, first
All
degree.
right.
It's a
So
M1.
you want to enter a no contest plea to those charges, sir?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
You happy with the work Mr. Powell and Mr. Stewart has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. You are to enter the pretrial intervention program. You can do mail-in reporting, and monthly supervision fees are waived, and take an anger management course. If you don't do these things, then you would could be sentenced and adjudicated on these cases. Okay? Anything else?
Go
All
ahead.
right, thank you.
Good work. This is a written plea.
Your Honor, I'm sorry, Charles Gray with state probation. We have to have the PTI agreement in order for him to start PTI. Usually, the PTI agreement is already drawn up. We get it from Your Honor, we send him over there instructing. That's when the PTI begins.
Can we set, Judge, can we set this for the 8th for control purposes for that?
Yeah.
Pretrial intervention
We'll do
agreement.
that. I think his attorney's out of town, really.
That's correct.
So what we'll do is set that for the 8th for control purposes to get that in, okay?
Can we, Judge, can we have the plea stand and Madam Clerk keep the written plea agreement? And we're just going to turn in the. That'll work.
Count 2 was not processed.
All right, no
right.
objection.
Okay, that's good. Charges are dropped on count 2. So he needs to come back on June 8th, is that correct?
Unless,
Maybe not. If I may, Your Honor, what I will do, we will prepare the PTI agreement, send it to probation, the form that we normally use, because this is a plea, a PTI is a condition of the plea, basically, something else. So I'll send it to your office, and then he can come and sign it.
Okay,
It won't, the PTI, we cannot begin the PTI until we instruct him and he signs it, Your Honor. So whenever that is, we're good with it.
all right. Well, let's get it done by, when do you think Mr. Powell will be back? Do you know?
Judge, if we can put it on the 8th for control purposes.
Put
if
it on
not-
the 8th, okay? All right. Thank you.
Yes, Your Honor. Your Honor, he also has one other client on the docket, Mr. Jason Miles. Mr. Miles is present before the court, Judge. Mr. Powell is asking to continue Mr. Miles' case. He has some additional work that he needs to do on behalf of Mr. Miles.
No objection, Your Honor. If we could
June-
set this for the June 29th.
9th. All right, June 29th. Thank you.
Yes, Your Honor. Judge, that's all I have before the court may be excused.
Yes,
Thank you, Your Honor.
Oh, I've got you, you don't have anything on Lundy?
No, Your Honor. Mr. Lundy's case was dismissed. He was reinstated to probation.
Okay,
Sorry, I thought that was taken off the docket.
all right. Thank you.
Yes, Your Honor.
Very good.
Judge, I've got a plea I can call.
All right.
Crystal Hall. Judge, this is going to be a plea to a misdemeanor.
Okay. Where's she at? Right, okay, gotcha. Ms. Hall, would you please raise your right hand and be sworn? You swear the testimony you give before this court's true, so help you God?
Sir.
You want to enter in case number 20 CF 864, a no contest plea to a misdemeanor charge of petty theft.
Yes, sir.
It should be greater than 100, Judge. I hit the wrong key by accident.
Okay, so it's greater than, right?
Yes, sir, that makes it a first-degree misdemeanor. And the term of probation is 1 year, so that's what it'd have to be.
Okay, did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
You're under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
You happy with the work Mr. Williams done on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Withholds adjudication, 1 year probation, restitution, misdemeanor court costs, misdemeanor cost of prosecution, $50 PD app fee, $50,
Misdemeanor PD fee,
Oh, okay.
I think it's $50, Judge.
misdemeanor PD fee, automatic termination upon payment of restitution and cost. Restitution may be paid through probation. So probation is terminated upon payment of these things, correct?
Yes, sir.
Yes, Your Honor, that's the
All
agreement.
right. So faster you pay it, the faster you're off, okay? All right, thank you.
If I
Thank you,
may
Judge.
state the amount of restitution for the record?
Certainly.
Because we do have it, is $8,529.34 to the Florida Department of Financial Services.
$8,529.34.
34. Yes, Your Honor.
To Florida Department of Financial Services.
Yes.
Judge will stipulate to that amount.
Okay, I wrote that in there.
Thank you, Judge.
Okay.
And Your Honor, we'll request the supervision fees be waived
All right.
in addition to the restitution. I think, is that to welfare fraud?
Right, that's what the
Yes.
original offense was.
And if the court is inclined, the court can waive the 4% surcharge on that also, which will help her out a little bit.
Okay, I will.
Appreciate that, Judge, thank you.
All right. Is, who's here that's represented Mr. Seals? Mr. Moore is, I think is,
Case no more, sir. He's not practicing.
come on up, okay?
Yes, sir.
All right, you are Tyrone Christopher
Yes, sir.
Seals, 215 CF 1600. I think your attorney you retained, I guess, is Bert Moore?
Yes, sir.
And
He's
he's
not
been
practicing no more, so.
You need, you want, I guess, time to get another attorney or something? Is that what you're requesting?
No, sir. The situation is that on this case here, when Judge Flower was in the officer, and he recommended, after I do my term on my probation, that I served 6.5 years on it, and I complete everything that I had to do. Well, I've been on probation for 6 years and never got in trouble, but he's not judged no more. He had said that after 6 years, and I paid everything off, he would terminate it. So I came back a year ago, and the state disregarded because they said protect the victim, that the case that I'm in, but the state didn't have enough information on the victim, because the victim on this case that, what happened, he's been incarcerated. So me and Mr. Burt, we filed a motion again, and then after I don't know what his problem going on with him, but I decided to just come myself and see what was going on and see can I have everything terminated. Because I've been on probation for 6 years and 6 months, and I completed everything that I had to complete it while I was been on
okay.
probation.
So right now, I believe your attorney's been suspended, Mr. Moore. I think he's
Yes,
been
sir.
suspended, so Well, what does the state say on that? I mean, I'm not familiar with anything that Judge
Right.
Flowers may have said.
Your Honor, at the last hearing, Judge Flowers made no promises to early terminate this defendant at all. He originally pled from a first-degree felony, sexual battery with a physically resist person. He got the benefits back in 2016 of a downward departure to be put on 2 years of community control followed by 8 years of probation, and by pleading to a second-degree felony. So he's a sexual predator, but he's only completed a little over 6 years of the 10-year total supervision. So the state's intent, I would assume, I was not the original prosecutor, but to get such a benefit of a downward departure on a sex case like this would be to have him be punished by serving the entire 10 years and to protect the victim. I'm not sure of the victim's situation, how long the incarceration is or where the victim or if the victim's incarcerated, but he has to register as a sexual predator no matter what. And it looks like he's filed the same motion for early termination since August of 2021. This is a motion that he keeps filing the same exact piece of paper, the motion, and it looks like he quotes he wants to live a peaceful life.
Let me ask you this: has there been any law violations in the last 6.5 years?
Judge, in April of 2017, there was a GPS gone alert for 15 minutes that was reported to the judge, and I believe the judge it was one of the.
Why don't we do this? We'll continue this to June 29th, and would you get a hold of the victim?
Would judge, if they're incarcerated, I wouldn't. I mean, I could send a letter. He says the victim's incarcerated, so I could research and see where that is. But
Judge, if somebody will give me the victim's name, I can pull it up on the DOC website and tell you if
I
they're.
hate to say the victim's name.
it's redacted in discovery, so.
Yeah, I don't know what the victim's name. I don't want to say. Don't say it. Well, just go over there and tell
Over
Mr.
and tell me privately, so it's not passed over the internet.
The victim is in. You're saying. Ms. Glisson, you're saying the victim's in prison? The victim's in prison? Is that what you're saying?
I don't know, Judge. I don't even know the victim's name is not in the information. We use initials. But Mr. Berry says he knows
I know
who the victim is.
Hang on a second, wait for the
He can pull it up in a
thing to
second.
come up.
I'll give him the name.
What?
Your Honor, there have been motions in the past that have been granted. He's requested to travel, and the courts allowed him leniency to travel with permission from the probation officer, and the courts allowed him to work with the probation officer to amend the curfew. So it's the state's position that the minor inconvenience of him being on probation as a sexual predator doesn't outweigh the need to keep the defendant on probation for the entirety of the sentence, given he was given such a huge benefit of not going to prison, and
Let's
instead.
see what, I mean, if the victim's in prison, I mean, the victim's. Let's just see what we find out about if the victim's in prison and. The victim's last name. While this is going on, Miss Courtney, let me see you up here for just a second.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
March 30th of 2023, and the release date is September 1st of 2023. So almost, the victim will be released in 3 months.
Why don't we just continue this to June 29th and see if you can get some information from the victim, what their position is.
Judge, would it be possible just to set it after his release date? Because I'm not sure how I would
All right,
communicate.
since he's out of custody, we'll do it that way.
Okay. Maybe late September?
September 28th.
Okay, thank you, Judge.
If you find out something sooner,
Yes, sir.
then we'll pull you up quicker
Okay.
and see about terminating, okay?
Yes, sir. Can I say one thing?
Sure.
On this case, sir, that it took place on the record, this case was dismissed by the Crestview Police Department because there was a lack of interest of this person. And it took 2 years for them to find this person to go on with this case. And the only reason the state went on with the case because they falsify a
All right, we'll check into that too, if you don't mind, see if it took them 2 years to. Okay, I'm new
understand what
to it.
you're saying.
I'm new to the case myself.
Yes, sir.
I'm trying to give you a chance to, considering it. I didn't
understand
just
what you're
say, I
saying.
didn't say denied.
right.
Okay, so I just want to check on a few things, and we'll bring you back as soon as we can. If we can find out some information.
Right.
I mean, if he don't respond, the victim don't respond or doesn't care, I mean, let me know real quick. That is, so we'll put it on, what about September 28th?
Right.
Yes, Your Honor, that's fine.
Thank you, sir.
Yes, sir. Because, see, there's a lot going on with this case. Just, I
Well,
understand what you Thank you.
Trying to do what I can.
Yes, sir.
Next case. Is Mr. Williams here? All right, Mr. Williams, this is 22 CF 661, and you are also represented by Mr. Moore, I presume, and he's been suspended.
Yes, sir.
What are we here for today, Ms. Boston?
I'm petitioning the court to end my probation early since
Do
I've...
you want to get another attorney?
No, I don't think I need one.
What is
Your Honor,
Ms.
I'm sorry, Mr. Williams entered a plea to 2 counts of providing marijuana to a minor, which was third-degree felonies. He was placed on consecutive 1 year, I'm sorry, they were misdemeanors, he was placed on consecutive probation, 1 year each, back in August of '22. We don't believe, Your Honor, that it is appropriate to allow an early termination in Mr. Williams's case. He was given a break up front. There was a null clause of another felony. And so we do ask that the court maintain him on supervision for the duration of the 2 years.
That is incorrect, Your Honor. I ended up with contributing to the delinquency of a minor, not...
Possession of marijuana to a
Right.
minor?
No.
And I corrected
That
myself.
wasn't specified.
I mean, what?
Your Honor, he originally was charged with the providing the marijuana to a minor, which was the felony, and then, as I corrected myself, that he pled to the misdemeanors.
So he
which
was
were the
put,
contributing
he
delinquency.
was put on probation for 2 consecutive years
2 consecutive years, Your Honor, yes.
on August of 2022.
August of '22, yes, Your Honor. We're not quite a year into it at this point. That, even if the court were to consider early termination, that's normally not before 2/3 if they've done everything right, so we're not even at that point, Your Honor.
We'll set him for November 2nd and see how he's doing.
Thank you, Your Honor.
Come back on November 2nd. Okay?
Yes, sir.
Thank you. Next case.
Yeah, I'm done.
We have Zachary Packard. That,
Charles Russell, Public Defender's Office, Judge. This is my Kelton Lett, number 15 on your docket. Couple things. Mr. Lett had filed a motion for a Nelson hearing and motion for ineffective counsel after I filed my motion for bond hearing. So I think we should probably deal with his motions first and then deal with
all
mine.
right.
if
And
it's still on.
Mr. Lett, would you raise your right hand to be sworn, please? You swear the testimony you give for this course is true, so help you God.
Sir.
All right, you filed a motion on a Nelson hearing, you saying that Mr. Russell is ineffective. He's filed a motion for bond for you.
It's like ever since, I'm sorry, Your Honor.
Okay.
Ever since about 7 months, I've been asking for him to file for effective for a psych evaluation. I really take medicine on the street, and he haven't been doing that. Like, I've been asking him to file for different kind of motions for me, and he started not trying to help me.
Well,
Like he did the bond hearing. That's the first start. He did that, but he haven't been doing what I asked him. I ain't been telling him what to do, but I'm not no lawyer.
I got you. Mr. Russell, have you filed demand for discovery for Mr. Lett?
Yes, sir, and we recently completed the depositions.
Taking depositions for Mr. Lett?
Yes, sir.
Have you been up to see Mr. Lett at the jail?
Yes, sir.
How many times?
Since I've had the case, 1, 2, 3, 4 times.
Okay, how many other times has someone in the public defender's office been to see him?
Looks like Ms. Hudson, who had it before me, went and saw him 3 times.
The lawyer's been up to see you seven times or so. They filed discovery. They filed a not guilty, filed discovery, took depositions. Have you given him copies of discovery and police reports or such?
Yes, sir. I've given him copies of the police reports and the 2 depositions that we took originally. We had transcribed. He's got copies of those. The depositions that we just took haven't been transcribed yet, so those haven't been provided yet.
Have you entered any type of plea negotiations on behalf of Mr. Lett with the state?
Yes, sir.
Have you reached any type of potential agreement?
No, sir. I think we're pretty far apart, but we do have an offer from the state, and I've conveyed counteroffers from Mr. Lett. But
All right, and if this doesn't come to fruition, you're prepared to go to trial for Mr. Lett?
yes, sir.
And you filed a motion for bond on behalf of Mr. Lett?
Yes, sir.
Mr. Lett, it seems like they're doing a lot for you, have done a lot for you.
I feel like he ain't on a trial. He don't even know what's going on in my case. He just trying to go to trial just to go to trial.
Well, I mean, he can't make the state give you some type of agreement. He's got, the option is plead, go to trial. That's it. I mean, if the state don't give you an agreement you accept, his only option is to go to trial or plead straight up or whatever they offer. He can't make them do it. He can't make them give you a deal. But he's trying to get, what we're going to do is I'm going to let him stay on your case. Sounds like he's doing good. Now let's go on to the Nelson hearing denied. What are we going to do on a bond?
Judge, we filed a motion for bond reduction back on May 12th. Mr. Lett has testified that he's been in jail, prepared to testify that he's been in jail since August the 7th of 2021. He has a current bond of $55,000 on his case. Mr. Lett would live in Crestview if the court granted him a bond that he could make. He's lived in this area for a year. He previously was employed at Taco Bell in Niceville. He has a child, a 2-year-old child. He has an immediate family member in the area, specifically a cousin. He completed the 9th grade of school, and he's not failed to appear in court when required to do so. If I could, let me ask him if he wants to add anything else. Mr. Lett doesn't have anything to add.
Prior record?
Maybe. The state is trying to verify an Alabama record.
And that record, Your Honor, would be burglary, possession, or carrying concealed firearm, and robbery with a weapon. We're in the process of obtaining the convictions for that, and also probation violation, I believe, was in there. Your Honor, we do not believe that there's been any substantial change in circumstances from the time the court set the original $55,000. Mr. Lett is charged with 4 counts of using a computer to solicit a minor, then traveling to meet that minor to engage in sexual conduct. I believe it was a 14-year-old thought he was coming to meet, also unlawful use of a two-way device. Based on those charges, he has a minimum guideline of 108 months up to 40 years. Your Honor, we would have concerns about Mr. Lett being a flight risk. He really has no ties to the community. At the time of his arrest, he was only in the area for 2 months. He had only been employed there. He came from Alabama. I believe his mother is deceased, and his father's living in North Carolina. So we do have concerns about him being a flight risk if he is released, especially with what he's facing. It would also require sexual offender designation if he is convicted. We ask the court to leave the amount as previously ordered. Additionally, if he is released, I believe the court previously ordered pretrial services with a GPS monitor and no contact with minors or electronics. We'd ask that those conditions also remain in place as a condition of any bond the court may grant.
Has he got a certain amount per count?
Yes, Your Honor. I believe it was $25,000 for count 1, and I believe it was a ROR for count 2, 3, and 4. Those are all the solicitation counts. 5 was another $25,000. That was the traveling count, and then 6 is the unlawful use, and that was a $5,000. Your Honor, we would also point out to the court something that might be of concern as well is a mental health evaluation was done at the time of his original arrest, and they did find that he was appropriate given the fact that there were some mental health concerns. So if he is released, we would also ask that that be a condition.
I'll reduce the 25,000 to 15,000 cash for professional. Both of those, the 5,000 to 2,500 cash professional, the others are ROR. And then with the extra conditions that the state's requesting.
Thank you, Your Honor. Would that also include the mental health evaluation and treatment
Yes.
disorder? Thank you.
Yeah, all right. So I reduced your bond. Thank you.
I'm sorry, Your Honor, there is one condition that pretrial always asks us to impose is if the court is ordering the GPS, which the court has ordered, that it needs to be attached before he is.
All right. Okay,
And the GPS at $1 a day, Judge?
yeah. All right, so you got your substantial reduction in your bond. Thank you.
Thank you.
Thank you, Judge.
Grace?
Billy Grace,
Yes, I am.
all right, does Mr. Grace, my record shows here that you have no attorney, is that correct?
Sir?
You have no attorney? Oh, you have Ms. Rivers?
No, Your Honor, I believe that he has Mr. Gibbs on another case.
Yes, I am Mr. Good.
Okay.
And Mr. Gibbs is seeking appointment for this case as well.
Oh, okay. I'll appoint the public defender to represent Mr. Grace.
And Your Honor, at this time, we would enter a denial.
All right. We'll set him for,
Your Honor, may I ask, he also has a new law case. Can we track both?
all right.
And I'm not sure when the new law is set for, is it for this pretrial in June or next? Thank you. Okay, then it's fine for 6/26? Thank you.
Okay, June 26th, thank you. Zachary Packard.
Your Honor, I haven't been appointed to this case, but I did want to just stand in because I was appointed to his new law, which has since
I'll
been
appoint
dismissed.
public defender to represent him.
Your Honor, prior to doing that, this is a case where the violation of probation was based on a new law offense, and that new law offense was dismissed, so the state would be asking the court to dismiss the VOP and reinstate him to probation.
And Your Honor, you don't have to appoint me. I just wanted to talk to him and let him know what I talked to the state about.
Thank you. All right. So the state is going to dismiss the violation of probation and just reinstate him to his other probation?
We're asking the court to do that, Your Honor, yes.
All right. He doesn't need to enter any kind of plea or
Correct.
anything. Okay, I'll do that. You have any objection to that?
No, sir.
Okay.
I was just curious if I'll be reinstated where I left off on my probation because I only had a couple months left.
Yeah.
Yes. with
Yes,
all
sir. Thank
original-
you.
All
Let you-
original terms and conditions.
Let
No,
you
thank
out
you.
today.
All righty. Thank y'all.
All right, thank you. We have Christina Pittman?
We
We
did,
did
Your
it.
Honor.
Did we do Hall? Crystal Hall, we did that.
I don't have all.
We did Rachel Litton.
Oh, Crystal Hall? Yes, sir, we did Crystal Hall.
So we did everybody. Did we
Ms.
do-
Linton, we did last week, Judge.
Did we do Seals?
Yes, sir.
I don't see anyone else. Do we have anybody else at y'all?
I don't have any other cases, Your Honor.
All right. Let me see. Can I see all you public defenders, state attorneys in my chambers for about a 10-minute quick meeting?
Yes, Your Honor.
Okay.